Hi, my name is Dinesh. Today we're going to discuss about measures affecting importation of salmon from Canada into Australia, and which is a dispute which stayed for 25 years from 1975 to 2000, and which was settled in 2000 May by a judicial organization which is involved in it. And I will talk about the involvement of this judicial organization, which is World Trade Organization, in my third slide. And in this PowerPoint, each slide has a separate video description of the slide which we're talking about. And let's go for the next slide. Thank you. In this slide, I'm going to give an introduction of this case. So the case involved a dispute between Australia and Canada for the importation of Canadian salmon into Australia and the Australian quarantine restrictions. And after this, the parties have submitted their dispute to the dispute settlement bodies or dispute settlement mechanisms, which is the World Trade Organization. So the dispute settlement body, DSB, the DSB is an associate degree authority created underneath Article 4 of 1993 agreement establishing the World Trade Organization, and therefore the WTO's understanding on rules and procedures governing the settlement of disputes. So the DSB is also accountable for imposing the DSU means dispute settlement understandings. So in this case, Canada complying to the WTO about Australia's quarantine restrictions, and therefore the measures accustomed to stop the industrial importation into Australia of fresh, chilled or frozen Canadian salmon underneath Quarantine Proclamation 86 Act. So this Proclamation Act basically says that in the opinion of Director of Quarantine, any importation of dead fish of the suborder salmon or any parts of fish of that suborder have been should be subjected to such procedure so that it won't spread any contagious diseases or disease germs or pest contaminating germs. So accordingly, so this fresh salmon or any kind of seafood should be high heat treated salmon. So the products are consumption as well as non-commercial quantities of other salmon, primarily for scientific purposes. However, raw, chilled, or frozen salmon, uncooked salmon cannot be imported. So Australia carried an import risk analysis (IRA) for ocean cod Pacific salmon. The outcome of the risk analysis was first outlined in 1995 draft report and revised in May 1996 and finalized in December 1996. So I'm going to talk about the Canada's claim in this category of salmon which was the basis of the risk analysis, should be distinguished by the risk analysis from different classes of salmon. So we know that there is an involvement of a judicial organization in this dispute to settle the case peacefully between Canada and Australia. So the organization which is involved in it is World Trade Organization. So it's the only international organization dealing with the global rules of trade among nations. Its prime objective is to ensure that trade flows as evenly, predictably and freely as possible. So WTO settled this case in May 2000 peacefully between Canada and Australia. So both of them agreed with the settlement. And in the coming slides, my friend is going to explain about the panel process and the settlement of this case by WTO. So that's it for today with me. Thank you.
I am further going to discuss the panel process and the legal aspect regarding the dispute. This dispute was started on October 1995 on the basis of complaint done by the Canada to WTO, and the panel was settled on April 1997. This panel had submitted to the dispute report on June 1998, which stated that the ban was inconsistent with several such as 2.2, 2.3, 5.1, 5.5 and 5.6 agreements. A new report was submitted through appellate body in October 1998 because the notice was sent to appellate body in 1998 against the original panel. Both the report were accepted by the DSB. On the basis of the report, Australia was asked to lift the ban on the salmon imported from the Canada and also quarantine requirement for other fish products. On Canada's request, arbitration on reasonable period of time was circulated on 23rd February 1999. The period provided for this was 8 months. Again in 1999, new panel was established to determine whether the measures have been compiled or not, and the panel found that the measures were not compiled as the Article 5.1 and 2.2 of the SPS agreement were breached. After discussion on the report and the panel's decision in the DSP meeting, the settlement agreement between Canada and Australia was done, which came in place on June 2000. Legal issues in dispute. Risk assessment. Article 2.2 and 5.1 are based on risk assessment of the product. The ban was not scientifically justifiable by being based on a proper risk assessment or an international standard. Second one, consistency. Article 2.3 and 5.5 related to prohibition on discrimination and in this case restriction on international trade were unjustifiable when considered in light of the treatment of other imported fish products. Third one, least trade restrictive measures. Article 5.6, based on the appropriate level of protection, was also breached in this dispute. The measure was more trade restrictive than necessary to achieve the appropriate level of protection.
Hi, my name is Ziran Kumar Patel. Today I am going to conclude about Canada and Australia measure affecting importance of salmon. Following the release of the appellate body report, Australia informed the DSP on 25 November 1998 that pursuant to Article 21.3 of the DSU, it would implement the recommendation and the ruling of the DSP in this dispute. In doing so, Australia stated that although it would be mindful of Article 3.5 of the DSU, it would require a reasonable period to complete the implement process. Although Australia was disappointed with the finding and the conclusion of the appellate body report, its reaction above was in accordance with the tenor and spirit of the establishment of a DSB and the DSU. The DSP provides its general term the procedure for the settlement of dispute between the member states of the WTO. The procedure relies on consultation, good offices, conciliation, mediation, and the panel and appellate body proceeding. This procedure, unlike arbitration, do not result in binding decision, and the panel and appellate body may only make recommendation. In other words, the success of this mechanism depends on the good faith of the disputing parties. However, in the WTO, the panel and appellate body reports become binding once the DSP accepts them.